This video was made possible by Tab for a Cause. Raise money for charity just by opening tabs in your browser. With the Mueller report out, we finally have some answers about Russian efforts to interfere with the 2016 election and the administration's efforts to stymie that investigation. But some of our original questions remain unanswered. The report raises new questions, and now we have to start thinking about next steps. Hey Legal Eagles, today we're talking about the known unknowns that remain in the wake of the redacted Mueller report. As we discussed in a prior video, Robert Mueller created a legal framework that would not have allowed him to indict a sitting president or to levy formal charges against the president on fairness grounds. The issue from a legal perspective is we don't know if Mr. Mueller is correct about the unindictability of the president. This is largely a constitutional question. We have memos from the Office of Legal Counsel, the OLC, that talk about this, but the OLC memos themselves are not consistent on this point, and the OLC itself is an arm of the executive branch, so it would not be surprising if they took the view that their boss cannot be indicted while sitting in the executive office. The only way to know if a sitting president can in fact be indicted or to have formal charges levied against them is to test it at the Supreme Court. And Mueller's framework that he created certainly doesn't allow for this possibility. Which leads us to the second open question, which is what about the statute of limitations during the pendency of a president's tenure? Mueller takes the view that he cannot indict a sitting president. We don't know if he actually would have indicted the president, but he takes the position that he is not even going to get to that question. But because we don't know if Mueller is correct, we also don't know what happens to potential crimes that a president committed before taking office. Generally speaking, most crimes have a statute of limitations. It's in society's interest for most things to be able to lay to rest certain offenses that happened so long ago that it would be impractical to try and get a conviction years or decades after the fact. So there's a sunsetting provision after certain offenses have happened. It's not true for all crimes, but it certainly applies to most of the things that you can imagine a president having done before or during office. With respect to obstruction of justice, Section 3282 of Title 18 of the US Code is the general statute of limitations that applies when there isn't a more specific statute of limitations. It states that except as otherwise expressly provided by law, a prosecution for a non-capital offense shall be instituted within 5 years after the offense was committed. So unless there is a more specific statute of limitations in the federal system, it's generally a 5-year statute. So practically speaking, even if a sitting president committed the crime of obstruction of justice, what happens if the president is president for more than 5 years? What if the president wins a second term and has committed this particular crime? Theoretically, if a president committed a crime of obstruction of justice and then won a second term, then becoming president could be like a get out of jail free card, which I don't think anyone would support. And that also raises the questions about offenses that might have been committed before taking office. Those offenses may not have a 5-year statute of limitations. There could be a 2 or 4-year statute of limitations for fraud-related offenses, or there could be a very specific 1-year statute of limitations, as sometimes happens in statutory law. This is an untested part of the law. Robert Mueller's position is perfectly reasonable that you cannot indict a sitting president, at least criminally speaking. And the corollary to that argument would probably be that, well, you can't actually indict the sitting president with a crime. That means that the statute of limitations should be told for that period of time. But it's entirely possible that if the question ever got to the Supreme Court says, no, Mr. Mueller was incorrect. You can indict a sitting president. And as a result, the statute of limitations is not told. And also, by the way, you waited too long to bring the crime, and therefore the statute of limitations has expired and the president can no longer be charged with this offense, even after leaving the presidency. That's the problem with having these untested constitutional questions that only the Supreme Court can answer in this context. Which brings us to the next open question. We don't know to what degree of certainty Mr. Mueller thinks that the president may or may not have committed the crime of obstruction of justice. And knowing to what degree of certainty the evidence rises, would probably help the electorate and members of Congress to know what they should be doing in terms of next steps. While the Mueller report itself is often silent about how strong Mueller thinks the evidence is, Attorney General Barr, in his press conference shortly before the redacted Mueller report was released, said that Mueller told him in person that he wouldn't have found a crime even in the absence of the legal limitations that were created as a result of the framework under which Mueller operated.
On March 5th, we specifically asked him about the OLC opinion and whether or not he was taking the position that he would have found a crime but for the existence of the OLC opinion. And he made it very clear several times that that was not his position.
Frankly, given the descriptions of the factual evidence regarding obstruction, it's hard to believe that Mueller actually said he would not have made an actual determination. In fact, the Mueller report itself says that it goes to great pains to avoid the traditional prosecutorial decisions. And in fact, the Mueller report says that while he did find evidence of conspiracy to collude with Russians, that evidence did not rise to the level of a chargeable offense. So if Mueller was capable and willing to find that the evidence did not rise to the level of a chargeable conspiracy with respect to Volume 1 of the Mueller report, it doesn't make any sense that he would have in secret felt the same way about Volume 2, the obstruction offenses, but left it out of the Mueller report itself and only told the Attorney General William Barr. That, frankly, does not sound accurate. Which leads me to the next open question about Attorney General Barr. In Barr's 4-page summary of the Mueller report, Attorney General Barr states that he, along with Deputy Attorney General Rod Rosenstein, looked at the evidence that Robert Mueller created regarding obstruction of justice and came to a determination that there was no obstruction. We don't know how Barr and Rosenstein came to this determination. And we also don't know if it was based on Barr's view of the evidence and facts, or whether it was specifically based on Barr's view of the president's Article 2 power. As we covered in a prior video, Barr has a fairly idiosyncratic view that if the president is exercising his Article 2 power, it cannot possibly give rise to the crime of obstruction of justice. The exercise of that power is effectively unchecked by the judiciary. There are some scholars that agree with that view of power, but most people disagree. So it's important to know how Barr and Rosenstein came to the conclusion that there was no obstruction of justice. We also don't know what is behind the redactions of the redacted Mueller report. By one count, there were 855 separate redactions on the basis of things like harm to ongoing matters and grand jury testimony that is protected by Rule 6E. On the one hand, this is not the most redacted document I have ever seen in my legal career. I've seen documents that are far more blacked out than this. And it's hard to argue that redacting information on the basis that it's going to harm an ongoing criminal investigation is a bad thing to do. But on the other hand, given the disparity between the Barr 4-page summary and the actual redacted Mueller report, I'm not sure that this Justice Department deserves the benefit of the doubt with respect to the redactions that were made. So it is an open question as to what is underneath all of these redactions and what we will see in the weeks and months going forward as it is tested in the courts, whether this information can be unredacted and released to the public or to Congress. Additionally, in one of the appendices to the redacted Mueller report, there are 12 referrals that started with the Mueller investigation that were made to other U.S. attorneys' offices throughout the country. Many of those referrals are completely unknown. It is blacked out what the referral was, what the subject matter was, and we have no idea what is going to come of these investigations that started with the Mueller report, but were farmed out to the other U.S. attorneys' offices throughout the country that have subject matter jurisdiction over the rest of these criminal investigations. Now, in terms of some of the questionable decisions that the Mueller team made, at least from a legal perspective, we've already talked about the legal framework that Mueller created that may or may not be constitutionally mandated. But one of the things that really sticks out as an attorney is Mueller's decision not to interview the president. Mueller stated that he viewed his role in this investigation as a fact finder, not to come to a conclusion about whether a sitting president has committed a crime or not, but to be able to gather the relevant evidence while it was still fresh, while the witnesses were still available, to be able to compile that so that other people and other entities would be able to make those determinations. So given that, it is odd that the Mueller team decided not to interview the president. Again, that might have been the right decision, but it is an odd one in the context of a fact-gathering mission. So instead of interviewing or deposing the president, the Mueller team decided to issue written questions that the president was able to respond to in writing, having had his attorneys look over all of his answers. I tweeted out after the Mueller report was issued that depositions are better than interrogatories. And what I mean by that is, in the civil world at least, you have mechanisms in discovery to be able to interview witnesses or to ask them written questions. Written questions are called interrogatories. And these interrogatories can be useful, but the problem is that the opposing side will review it dozens of times through their attorneys so that the information that you receive is not particularly useful. Getting someone in front of a camera, in front of a stenographer under oath and asking them oral questions is almost always a far better way to understand what they were thinking, why they did certain actions, and to actually get at the truth. Credit where credit is due, I would say it was a very smart tactic of President Trump's attorneys to prevent and delay him from sitting in front of an oral deposition and in issuing these written answers that are very, very safe and basically don't say anything that could incriminate the president. It was good legal advice. We, of course, knew that the president was given written questions, but until now, we were not able to see them. Now, we can finally see the questions and answers that are listed in Appendix C to the redacted Mueller report. Almost all of the president's answers come in the form of "I don't know" or "I don't recall," which is, of course, a very, very safe thing to do. It is hard to get locked down in terms of lying under oath or committing perjury when you're simply saying that you don't have a specific recollection of the thing that is asked of you. The amount of "I don't knows" and "I don't recalls" is interesting also for the fact that the president has claimed to have one of the greatest memories in the entire world.
One of the great memories of all time.
But that's the issue with getting written answers. They aren't written by the answerer. They are written by the lawyers and simply signed onto by the person who was asked the questions. But Mr. Mueller says that he found Trump's written answers to be, quote, inadequate, and says that the special counsel had the power to subpoena the president to make him sit for a deposition. But Mueller refrained from doing so because issuing a subpoena would impose, quote, substantial delay, and he felt like he already had enough information. Those are not unreasonable concerns, but given the circumstances, this would have been a very difficult decision, and only time will tell whether it was the right one. So in the wake of the Mueller report, let's talk about next steps. Mueller recognizes that impeachment is the preferred and constitutionally sanctioned mechanism here. He specifically states that Congress can in fact police wrongdoing by the executive. Whether the allegations of the Mueller report rise to the level of impeachment is a political question that I will leave to you. But Mueller and his team concluded that Congress does in fact have the authority to police obstruction of justice, stating, "We concluded that Congress has the authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice." I think it's clear that the reason that this is in the Mueller report is that this is a rebuke of Attorney General Barr's view that you can't use the president's inherent authority as a predicate for obstruction of justice. Mueller and his team did not buy that argument. Moreover, Mueller recognizes that actual criminal prosecution is an option after the president leaves office, as does the OLC memo on which the DOJ policy not to indict a sitting president is based. Specifically that, quote, "the president does not have immunity after he leaves office." This is a further rebuke of Barr's view about the constitutional unitary executive defense that would otherwise have prevented a sitting president from facing charges related to actions that he or she took while in office. House Judiciary Chair Jerry Nadler has issued a subpoena for the full Mueller report and the underlying evidence related to the investigation. It remains to be seen what could be contained in those redacted portions. And of course, we've talked about the referrals that are out. There are dozens of cases that were referred out, and we don't even know the first thing about the nature of those cases. There are also rumblings that a few Democratic members of the House are pushing for impeachment hearings. Whether this is a good political move or whether impeachment even has a chance of passing is beyond the scope of this channel, and that's a political question that I will leave to you. But here's what we can know for sure about the next steps. Number one, the courts will decide whether to release the unredacted Mueller report and the underlying evidence. Number two, the dozen or so referrals to the other U.S. attorneys' offices will likely result in further indictments. Of whom, it's anyone's guess. But recall that one of those referrals led to the president's personal attorney's office being searched, and that's a huge deal. It's likely that at least some other people will be indicted. And number three, elected representatives will have to decide whether to move forward with impeachment. Impeachment is a political tool, and it will be up to the politicians to decide whether to use that measure or not. One other potential next step is perhaps do some good for this world. If this video leaves you wanting to make some positive change in the world, I'd recommend Tab for a Cause, which lets you raise money for the charity of your choice just by opening tabs, which you were going to do anyway. Tab for a Cause is a Google Chrome extension that allows you to pick the charity of your choice, and then every time you open up a new tab, instead of it being blank, it displays a couple of ads, and the money that you generate is donated to your charity. There is no charge to you, and it actually does some good for this world. Tab for a Cause users have raised hundreds of thousands of dollars for charity. It's the easiest possible way to do some good in this world. So all you have to do is just click the link in the description and sign up with Tab for a Cause. And do some good by doing what you were going to do anyway, by browsing the internet. Do you have other open questions? Do you agree with my analysis? Leave your objections in the comments and check out my other real law reviews over here, where I will see you in court.